Good morning. It's 8:45. I see quorum, and we have our witnesses in place, so we are about to commence. Prior to commencing, however, I just wanted to say to both witnesses and to members that there are several investigations underway, one of which is criminal, and I would be very concerned about anything that might be said, either in questions or responses that would compromise any investigation. So with that caveat, I'm going to call upon the witnesses, and I think the first witness is the parole board. Jennifer Oates, I'll ask you to introduce your colleagues, and then after that, Ann Kelly from Correction Services Canada, and I'll ask her to introduce her colleagues. My intention is to go through the first hour of questions and then see whether there is a need for a health break at the end of 1 hour, and thereafter to proceed for the second hour of questioning. With that, I call on Jennifer Oates of the Parole Board to make her opening statement. Thank you.
Good morning, Mr. Chair and members of the committee. Je suis accompagnée aujourd'hui de Sylvie.
I am joined today by Sylvie Blanchette, the Executive Vice Chairperson, and Martin van Ginhoven, the Regional Director General of the Quebec office. I would like to start by extending my deepest sympathies to the family and friends of Marilène Lévesque. What happened in Quebec on January 22nd is an absolute tragedy. It is something that should never happen.
We are here today, and I want to take a couple of minutes to put a frame around that. On September 19th, 2019, a parole hearing was held for this offender. 2 parole board members reviewed his case to decide whether or not to continue his day parole. During this hearing, the parole officer presented to parole board members a release plan that included an element that would allow this offender to solicit women for sexual purposes. The parole board members rejected this part of the plan categorically. I want to be very clear about this. They ordered the offender and his parole officer to stop this activity. The offender clearly understood this, which is confirmed in the recent court statement. The rest of the plan was approved, and a decision to continue day parole was made with a number of conditions, including to report any relationships with women, whether sexual or non-sexual. On January 22nd, we were advised that this offender had been charged with the murder of Ms. Lévesque. Following that, there was much misreporting and misunderstanding about the conditional release system, so I'd like to provide a few clarifications. Mr. Chair, firstly, the Parole Board is an independent administrative tribunal, which means our decision-making remains free from external and/or political influence. This independence ensures that parole board members' decisions are made solely on the law and the information available to them. Secondly, public safety is the paramount consideration in all parole board decisions. That is the law. Thirdly, the board does not prepare offenders for release. It does not manage or supervise offenders on release. That's the responsibility of the Correctional Service of Canada. The board is a decision-making body, and we conduct approximately 16,000 reviews a year, which translates into about 23,000 decisions. Violent reoffending by offenders the board has released into the community is extremely rare. 99.9% of all offenders on day parole have not reoffended violently, and these numbers have been consistent over the past decade. However, when an incident like this occurs in the community, we take it very seriously. A board of investigation is now underway, as is the normal practice following this kind of incident. It is being co-chaired by two independent, external individuals who are criminologists. The board is fully invested in finding out what happened in this case and to see if there are things we could do better. La motion présentée à la Chambre souligne.
The motion of the House also notes concern about the appointment process of board members. The process to become a parole board member is open to all Canadians. It is merit-based. There is a screening process, a written test, interviews, and reference checks.
Names I forward to the Minister for his consideration are all highly qualified individuals that could become good, very good board members. The Parole Board is a community board. We are, by law, to reflect the diversity of Canadian society. Board members have diverse backgrounds, spanning the fields of criminology, law, corrections, education, psychology, social work, and the private sector, to name but a few. We currently have 78 board members, 39 full-time and 39 part-time. Part-time board members are appointed for 3 years as prescribed by law, and full-time board members are currently appointed for 5 years, although the law provides for up to a 10-year appointment. The board, over the past few years, has improved its diversity to better reflect that of the Canadian population. 53% are women, 7% are visible minorities, and 12% are Indigenous. 95% of board members have a university degree. 64% have direct experience in the criminal justice field, and 32% have direct experience in corrections and conditional release. Après avoir été nommés, tous les...
Upon appointment, all board members complete an intensive 6-week training program. In a nutshell, they receive training on relevant laws, policies, and risk assessment for various offender types, such as women, Indigenous persons, lifers, sex offenders, and others.
Coached by their respective regional vice chair, other experienced board members, and training staff. Absolutely no board member is assigned any decision-making responsibilities until they have completed their training and have the full confidence of their regional vice chair. If the committee would like additional information on this training program, I would be more than pleased to provide it. Training continues on a regular basis throughout a board member's entire mandate. Parole board members are also supported by highly qualified public service staff. They include hearing officers, case review officers, training staff, and our board member secretariat. The law, and therefore parole board decisions, are based on research that clearly shows that gradual, managed, and supervised releases provide the best protection of society. The board's risk assessment model is evidence-based and has been adopted in a number of other jurisdictions. Over the last 3 decades, there has been continuous improvement in the public safety results the board achieves, and it achieves this in partnership with many others, the Correctional Service of Canada and many community partners. And it reflects the research that has continued to progress on risk assessment and the management of risk. In fact, when former parole board chairperson Fred Gibson appeared before this committee in 1990, the success rate of offenders released by the board who completed their sentence without incurring a new charge hovered around 70%. Today, it is over 98%. But as much as we strive for excellence in our decision-making, unfortunately, predicting human behavior is not, and likely will never be, and exact science. In the very rare instances, such as this case, where an offender reoffends violently, it is devastating to me, to our board members, and to our staff. En conclusion,
In closing, I want to once again extend my sympathies to the family and friends of Marilène Lévesque.
to them, to members of this committee, and to the Canadian public, that I take these incidents very seriously and I will review all recommendations that could help us continue to improve the board's decision-making. Thank you.
Thank you, Ms. Odes. Madame Kelly.
Merci. Monsieur le Président, je suis accompagnée aujourd'hui du commissaire principal, Monsieur Alain Tousignan, et du commissaire.
Good morning. I am here with Alain Tousignan, Senior Deputy Commissioner, and Larry Mochek, the Assistant Commissioner in Policy. First, I wish to express my deepest sympathies to the family and friends of Marilène Lévesque for the terrible tragedy that took place in Quebec on January 22nd. This is not an outcome any of us ever want to see. We are committed to getting answers for everyone affected by this. As you know, there are 2 investigations underway. The first is a criminal investigation by the Quebec City Police, and the second is a joint Correctional Service of Canada and Parole Board of Canada investigation.
Aspects of this case and involvement by 2 separate organizations. This joint investigation is key to getting a comprehensive account of what happened. All 5 Board of Investigation members are skilled and experienced, bringing various perspectives to this process. 2 external community board members, who are also criminologists, are co-chairing the investigation. This brings added openness and transparency to the process. Once the investigation is completed, we are committed to communicating the results with this committee and Canadians. Je vais être très clair. Le service.
I want to be very clear. The CSC does not condone offenders seeking sexual services. I am in my 37th year with the service, and I can firmly attest to the fact that this is not something that we, as an organization, endorse in how we manage offenders, and this is something that concerns me.
Committee that CSC does not condone offenders seeking sexual services, and I am greatly concerned by what happened. I am in my 37th year with the service and can firmly attest to the fact that this is not something that we, as an organization, endorse in how we manage offenders. I have made this message very clear throughout the organization and ordered a review of all community strategies across the country as an added measure. Until the investigations are completed, I cannot speak to the specifics of this case, but can outline the case management and conditional release process. CSC's approach is governed by a very comprehensive piece of legislation called the Corrections and Conditional Release Act. Public safety is the most important consideration that underlies everything we do. During the incarceration period, public safety is achieved by ensuring the secure custody of the offender and maintaining a safe environment for both staff and offenders. But incarceration is only a temporary solution, as the vast majority of offenders will eventually be released into the community and become our neighbors. Therefore, an equally important job of corrections is to prepare offenders to safely and successfully return to the community as law-abiding citizens. Dès que le délinquant est condamné,
as soon as the offender receives their sentence, the process begins of assisting them to become law-abiding citizens. Each offender has their own correctional plan, which is based on addressing the specific factors that relate to their criminal behavior. All of the interventions for the offender to solve the problem are taken into account, and they're described in the correctional plan. That plan acts as a yardstick against which the offender's progress can be measured throughout the sentence. The offender's progress in meeting the requirements of their correctional plan is a significant consideration in any decision related to the offender's case. Public safety is the paramount consideration. All offenders are eligible at some point to be considered for some form of conditional release. Federal correctional legislation sets out various types of conditional release that provide offenders with gradually increasing degrees of freedom and trust that help make their transition safer.
The sentence is over. Not at all. Conditional release means that the offender is serving that part of their sentence in the community under supervision and abiding by strict conditions. Community supervision is integral to our work, as research consistently shows that the gradual, structured, and supervised release process represents an effective means of facilitating a safe and successful reintegration. The assessment of the offender's risk forms the basis of any conditional release decision made by the Parole Board of Canada. CSC provides information to the board on the offender's criminal history, their involvement in programs and interventions, their release plan and release suitability, and ultimately makes a recommendation to the parole board, including a recommendation for conditions of release. In addition, community agencies, police, victims, and others provide input about an offender's ability to reintegrate successfully. This information assists the parole board in determining whether an offender should be released and under what conditions. When offenders are released into the community supervision is carried out by community parole officers who monitor the offender's behavior and compliance with release conditions. As part of this supervision, the parole officer maintains regular contact with the offender, as well as with police, employers, mental health professionals, the offender's family, and others who are involved in the offender's life. This ongoing appraisal by the parole officer provides a continuing assessment of the offender's risk to reoffend. If the parole officer has concern about the offender's risk to the community, the offender can be returned to custody. En plus de contrôler, d'encadrer et de surveiller.
In addition to monitoring and supervising offenders, an important part of a parole officer's job is to ensure that offenders are linked to community services, volunteers, and programs that can help them successfully reintegrate. In general, the more ties offenders have to the community, the more likely they are to make the successful transition. Building safer communities is a complex process, and CSC cannot work in isolation. It is just one component of the criminal justice system. CSC not only works closely with traditional criminal justice partners, but also relies on the participation and support of the community. Communities provide services to offenders and their families that are a vital part of an offender's safe reintegration. Our community partners include individual volunteers and community organizations such as the St. Leonard's Society and the Salvation Army.
And the vast majority return to the community. Assisting offenders to become law-abiding citizens is the most significant contribution CSC can make to keeping communities safe. Having started my career as a parole officer, I have a full appreciation for the nature of the work that our staff do on the front line. It is an important job with a critical role in ensuring public safety. This is why, in early February, in addition to meeting with the chief of the Quebec Police, I also met with the Quebec regional employees, who are deeply distraught by this tragic incident, to stress the importance to continue their vital work of supervising offenders in our communities. Although risk assessment is not an exact science, we manage risks through a robust framework of evidence-based decision-making, using the best available information with the assistance of the best tools at our disposal. While I do not want to undermine in any way the seriousness of what happened here, it is important to note that it is incredibly rare. This was also highlighted by the correctional investigator on February 25th when he appeared before this committee. He underlined that this is an extreme case. En fait, nous savons qu'en 2018-2019,
In fact, we know that in 2018 and 19, 99.9% of offenders successfully completed their day parole supervision period without recommitting a violent offense. Moreover, our results show that there was an increase in the safe transition of offenders into the community. For example, more offenders on conditional release successfully reached the end of their sentence without readmission in comparison with the results 5 years ago.
Recently suggested that CSC is resistant to change. I want to take the opportunity to set the record straight. We have shown much openness and commitment to making positive improvements to federal corrections. We have seen historic and transformative change in recent years. This past November, we eliminated segregation and implemented structured intervention units. Our correctional programs consistently deliver positive results in reducing reoffending, and we continue to focus on improving our culture. It takes sustained commitment, effort, and dedication to deliver good corrections. We know there is more work to do, and we remain committed to self-reflection and improvement. Public safety is at the core of what we do. This is an unequivocal responsibility and a prerequisite to successfully transitioning offenders to the community. When tragic events happen, we have a duty to closely examine our business and see what we can do better to serve and protect Canadians. En terminant, je tiens encore une fois à offrir.
In closing, I would once again like to express my most sincere sympathies to the family and friends of Marie-Hélène Lévesque.
Kelly, our first round is a 6-minute round. I just say to members, so that I don't have to cut you off in the middle of questioning, if you from time to time just look at the chair, and I can signal how much time you have left. With that, Monsieur Palouse, 6 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would like to start by congratulating the people who wrote your speeches, because listening to you, there's no responsibility for anyone. It's a bit disappointing. Ms. Oates, I would like to start with you. You know that we're here because everyone in the House of Commons voted unanimously to adopt a motion that condemns the decision by the Parole Board of Canada that led to the death of a young woman when an offender was on day parole. So did you feel a responsibility about that? Did you even think of giving up your job?
Come through the last part.
So when the House of Commons voted on the motion that condemned your organization's decision, did you feel responsible, and did you think that you should step down?
No, I didn't feel like I should step down. I think there is an opportunity to provide clarification. There were many mistakes and misinformation that were being perpetrated by both, I would say, journalists and actually members of the House in their misunderstanding of how our system works. But I have huge confidence in looking forward, in finding out if there are things that we could do better.
Je dois vous couper parce qu'on a du temps très limité. Mais là, ce que je comprends, donc...
Time. Sorry. So are you saying that members of the House of Commons and journalists don't know how things work? But we've heard from a number of people who work in the system who are very disappointed with the way things are going now, the way that decisions are taken, and the way that work is being done. So you feel that your organization is perfect and that you have no responsibility in the death of Marie-Hélène Lévesque?
Everything perfectly, but we do follow the law. And the law is very prescriptive. The law provides for all offenders at some point in time of their sentence to apply for parole. The law provides dictates actually when they can apply for parole. The law provides a framework from which board members must make their decisions, and then we use our own risk assessment tools that have been developed by not by us but by experts from around the world.
OK, parlons de l'évaluation du risque.
So yes, let's talk about risk assessments. So you were saying that the two board members, Joseph Lemy and Madame Fortin, had written in the report that Mr. Gallese had to stop having sexual relations with women, paid sexual relations with women. But at that time, with the risk assessment, there was a problem there. So why did they not put Gallese back in detention, knowing that he had a problem, and knowing that there was one of the things that he had said that he could see women to get sex, but that also he had a psychological problem, a psychiatric problem. The reports were not updated. They were 2 years old. There was nothing in his file that was working. It really was a risk individual, a high-risk individual. So what happened? Was it a lack of experience, a lack of competence? Why did they not send him right back into detention?
That particular decision for a couple of reasons. One, they're independent decisions, and two, there are currently 2 investigations going on. But I can say that the board members, in making any decision, take all of the information that is available to them and make a decision with the protection of society being the paramount consideration.
Parlons de la dépendance. Donc, vous me parlez de la dépendance.
So let's talk about independence. So there's the former public safety minister who went to meet with board members twice at annual meetings, and he asked them to speed up the process for releasing criminals. I present the reports and the dates for those meetings, and I was wondering whether the Liberals asked you to release more offenders, to speed up the process.
We can't speed up the process. It's written in law when people can apply for release. And in fact, 60% of the releases into the community are not made by the parole board. 60% of offenders coming back into the community are statutorily released. That means they're released at 2/3 after spending 2/3 of their sentence incarcerated. What the board does in those cases is actually sets decisions. But you can't speed up the process. It's written in law.
Mais il n'y a pas d'obligation de libération aux 2/3.
But there's no obligation to be released at 2/3 of the sentence. They have to be considered apt because there's been an increase of 25% of conditional release in Quebec.
Released at 2/3. And they must be released at 2/3. It's a statutory release by law, and the board does not make those decisions. So that's 60% who are released that way. 40% of those released to the board 40% of those released are released by the board decisions, either day parole or full parole release.
Okay.
And those times are prescribed.
Avez-vous été mis au fait de la lettre qui est...
Were you aware of the letter that was sent by former board members in November 2007 to the Prime Minister?
Not here at that time. My appointment began in January of 2018, but I was made aware. I have not seen that letter.
Donc, vous n'avez pas vu la lettre?
No, you haven't seen the letter.
Monsieur Iacono.
Monsieur le Président, et tout d'abord,
Thank you, Mr. Chair. I would like to start by extending my condolences to the friends and family of Marilène Lévesque. The tragic event that took place on January 22nd was in the media in Quebec to a great extent. But I'd like to remind everyone that according to the report from 2019 by CSC, the province of Quebec is one of the provinces where the rate of violent reoffending and reoffending in general is the lowest in Canada. So my first question is this, and it's for Commissioner Kelly. Mr. Gallese had already been charged in 2005. He was sentenced after murdering his spouse. He was recognized by the authorities as having a very jealous and obsessive behavior with his spouse and with women in general. Do you think or don't you think that it was quite imprudent to authorize him to go to erotic massage parlors and to frequent a very young woman? First of all, as I was saying in my opening remarks, I would like to say that Correctional Services does not support the solicitation of sexual services by offenders. With regard to the process for someone who has a life sentence, those persons are eligible for parole. There's a correctional plan that's developed for them, and there has to be a program for them that they follow. If the risk is reduced, there's a conversation with the case management team. They may support release, and then there's a community strategy, and the offender has to appear before the parole board, and it's the parole board that grants or refuses release. Thank you, Ms. Kelly. There's a Correctional Services document that states that between 2008 and 2018, the reoffending rate for offenders on conditional release went from 48% in 2008 to 61% in 2018, despite a few tragic cases like the one of Marilyn Lévesque. Could you talk about what Correctional Services Canada has done over the last few years to make this decrease possible? Yes, absolutely. First of all, Correctional Services always has room for improvement. We often look at our policies to see if they have to be adjusted. And we also have our programs. That's a big piece. We have correctional programs that focus on substance abuse, spousal abuse, violence. Those programs are very effective. Mr. Mochek could go into that. But offenders who enroll in those programs are at a lower risk of reoffending. There have been reports and examinations. When we get recommendations, we take them seriously. We change our policies. And I think that that's why, over the years, the success rate has increased. And the success rate has increased. I have the figures here. With regard to day parole, 5 years ago, it was 89.3%, and now we're at 92.2%. And for full parole, 5 years ago, we were at 85%, and now we're at 90.5%. Perfect, thank you. Ms. Odes, could you tell me whether the mental and psychological health of offenders is taken into account when their potential eligibility for day parole is decided?
The parole board reviews all available information. This includes the judge's comments, Crown comments, police comments. It includes psychological assessments, psychiatric assessments. It includes everything that the board considers relevant and reliable information so that they can make an overall decision. So yes, they do consider their...
Merci.
40 seconds.
Une dernière question.
Thank you. One last question. Can we attribute this violent reoffense to a lack of staffing at the Parole Board of Canada? Or in general, could you give us some ideas of changes that could be made to reduce the rate of violent reoffending?
No, we do not have a shortage of staff in the parole board. In terms of appointment of board members, is always a churn. Where we would like to be would probably somewhere about 90. board members, a combination of part and full-time. We're at 78 right now. Some term off, some term on. So
Thanks very much. Madame Michaud, six minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and thank you very much for your testimony. I would like to start by extending my condolences to the family and loved ones of Ms. Lévesque. That's one of the reasons we're here today, to pay tribute to her, not really, but in memory of her, to ensure that this kind of case never happens again. There are a number of significant elements in what you've said here today. When you say that there was a release plan that was proposed and that it included an element that would allow the offender to solicit sexual services from women, you say that the parole board rejected that categorically. However, it took place anyway, so it would have been the parole officer who decided to follow that plan. Is that what happened?
Au moment de
So at the time of the hearing, I think that what the president of the parole board said is that there were concerns. Day parole was extended for another 6 months, but it was made clear that that kind of activity should not continue. And correctional services, as I said, well, we do not support that at all. So even though you rejected that and you do not support it, then it's the parole officer the officer who decided to go ahead with the release plan and allow Mr. Gallese to solicit sexual services. Anyway, answer, no. That is something that the Commission of Inquiry will have to look into to see what happened after the parole hearing. So we can't know whether the parole board was actually aware of the fact that Mr. Gallese was going to massage parlors.
they said this could not happen at all, to stop immediately this activity, and added to, and included as a condition of his release that he was to report any kind of relationships with women, sexual or non-sexual, to his parole officer. The Board of Investigation will hopefully shed some light on what happened between the period that he was instructed that this was not to happen and the murder of Marilyn Lévesque.
Donc, c'est à ce moment-là qu'on a mis la condition en place qu'il...
So that's when the condition was applied that he had to report any relationship with women, be it sexual or not. Was his relationship with Ms. Lévesque reported? But that's something that the Board of Investigation will look into. All right. The parole officer was with him in the community. So he had a parole officer? Yes. So how often did he meet his parole officer to have an assessment of his behavior? Well, the frequency is established just before release, and it's confirmed at the first meeting with the offender. And once again, I can't talk about the specific case, but what I can say is that when it comes to a frequency of contact between the offender and the parole officer, there are a number of levels. There's the intensive level where the offender has to be seen face-to-face 8 times in a month. There are levels A, B, and C as well, and there the offender has to be seen 4 or 2 times a month. And this is based on the risk of the offender of reoffending and also the offender's needs. The level of intervention can be examined once there's stable behavior in the community, and then there's a case conference between the parole officer and his supervisor. And for this case, we can't know what the frequency was for meetings between the parole officer and the offender. Answer, no. That's something that the Board of Investigation will examine. We know that Mr. Gallese had a history of violence against women. He had murdered his spouse. He'd become very aggressive. He was very jealous. And I read in the media that he was starting to develop a relationship with Miss Levesque and that perhaps his behavior was starting to veer toward jealousy. Is that something that his parole officer could have highlighted and reported to the board? I can't speak of the specific case, but I can tell you that as a parole officer in the community, when you're supervising an offender, there are what are called dynamic factors. So there's the job status, emotional, personal relationships, family relationships as well. And those are things that we would examine, particularly since we look at the offender's criminal history, the cycle of offenses as well. So we would take that into consideration, yes. So there are certain procedures and measures that are established, like taking into account facts and statements by the offender. And the offender himself said that he wasn't ready to meet women. So how can we explain that in his release plan? He was allowed to meet women, not just for emotional relationships, but for sexual relationships. Once again, Correctional Services does not support the solicitation of sexual services as an organization, but that is something that the Board of Investigation will examine.
Thank you. If I may continue on that, you say Correctional Services doesn't support the practice of recommending that it's okay for, as part of a rehabilitation project for an offender who's still under sentence, to seek the services of a paid sex worker. When did that policy get put forth? Is that in policy?
Well, actually, our job is to assist offenders become law-abiding citizens. And that's why we develop correctional plans. And in the correctional plans, we set objectives that the offender must meet in terms of programming and interventions. So we don't condone offenders.
Okay, it's an offense. It's an offense to do that under the law, so you don't condone offenses. But in terms of this particular situation here, he was on parole from March, and that was one of his conditions at that time. Were you ever aware of that?
Aware?
Were you aware that his correctional plan, his rehabilitation plan, included that from March of 2019?
No, I wasn't aware. And as soon as I became aware, I was obviously greatly concerned. This is not something that we condone as an organization.
No, I mean, you've said that several times. When the parole hearing was held in September 22nd, you said in your first remarks that they were categorically rejected that aspect of the plan. And what you said subsequent to that was that they did not support that. It's a much more ambiguous statement, and the ambiguous statement was presented to the House of Commons in the quote from the board suggesting that they didn't really approve that and they expected a better recommendation in the future. So that seems to be a little bit of a nuance. But let me ask you this. When that parole hearing was held and that decision was made, were you made aware that your correctional officers were recommending that rehabilitation, that was part of the rehabilitation plan? Did you become aware of it then? Yes, you.
No.
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 You didn't become aware of it till after the death of Mary-Ellen Levesque.
That's right.
Okay, so this is all subsequent to that. No one thought it was important to advise you that this was going on, that this was so objectionable, that was suggested that Mr. Galice could commit offences as part of a correctional plan. No one brought that to your attention?
I was not aware.
Okay. Tell me now, you talked about the role of community parole officers in the supervision of the plan during your opening remarks, the supervision of offenders in the community by community parole officers. Can you tell me whether there were actual community parole officers working for CSC who met with Mr. Galice during his parole, or was it somebody else?
No, there were CSC staff.
So CSC staff, community parole officers, met face-to-face with Mr. Galice 2 to 4 times a month from the time he was on parole?
I don't know at what frequency, but there were CSC staff involved.
They were involved. Were they doing direct supervision? Did they meet face-to-face with him, or was that done by some third party?
The direct supervision was done by a clinical worker at one of the CRCs. And the way it works is that that clinical worker works with a liaison officer, which is a parole officer from CSC, as well as a parole supervisor from CSC.
But the parole supervisor and the liaison, there wouldn't be the ones providing direct face-to-face supervision of this individual.
No, it would be the...
So there's a third party that
yes.
does this, not the parole officer. This is contrary to your evidence, by the way, which says that when they're in the community supervision is carried out by the community parole officers who monitor the offender's behavior and compliance with release conditions. But that's not the case in this particular situation, is it?
Although, again, they work very closely with the...
I understand
what we
they work
call
closely,
the
but
ALC.
I'm just... You
Yes.
have community parole officers. You mentioned their role here and how they operate, and they're the ones who are assigned the task of, and I think it's in the notes that were provided by the Library of Parliament, it suggested that their role is very specific, that they're the ones who conduct the risk assessments, and they're the ones who report back the response for monitoring, supporting, and managing offenders in the community. They connect officers with programs and services to help them safely integrate, and they make recommendations on special conditions, and they meet their clients in the community at an offender's home, at a residential facility, or a CCC. But in this case, that's not done by CSC parole officers at all, is it?
It's done by the clinical worker at the community residential facility, but there are ongoing case conferences with the parole officer from CSC. Yep. And Mr. Tousignan worked in the Quebec region, so can probably add to what I'm saying.
Can I ask you this, though? I mean, this is very important because you're talking about a community correction facility. This is not operated by Correction Services of Canada. This is privately operated by a third party, correct? And this is an offender who's still serving a sentence, and the community parole officers employed by CSC are not dealing directly face-to-face. The ones who are trained in this work are not dealing face-to-face with people like Mr. Galiz, despite the high risk to reoffend. That's evident from what happened on January 22nd.
Again, Mr. Harris has asked an important question. Unfortunately, he's left you no time to answer it. I'm sure we'll have some time to circle back in on the answer. With that, Mr. Morrison.
Thank you, Mr. Chair. The parole board members wrote in their decision on September 20th in the Galiz file, and I'll just quote that. The Commission extends day parole for a period of 6 months since the board is of the opinion that recidivism before the statutory expiration of your sentence will not represent an unacceptable risk to society, and this release will contribute to its protection. That's the end of the quote. Do you find it worrisome, and this is for the chairperson, do you find it worrisome that a board member would write that a repeat offense before the statutory expiration of the Galiz sentence will not represent an unacceptable risk to society?
No, I don't, because actually it's in the law, section, and I'm going to 102. Do you want to? It is in the law that, there are two elements in terms of how a board member is going to make their decision. One is that they will not, by reoffending, present an undue risk to society. So that's where that comes in, and that reflects the law.
Would you say an experienced board member would make the same decision?
I will not go there. Each board member's decisions are independent, so the question's actually quite irrelevant.
Well, there was some board members who spoke to the media who said they wouldn't have done that. That's why I asked that question.
They were not present board members.
The daily newspaper La Presse reported the two board members adjourned for a few moments during the September 20th hearing when they learned that Galiz was meeting women. They went to ask for an opinion of a supervisor, the interim vice chair, Francine Quentin. Does that indicate maybe that there's some lack of experience?
Absolutely not. We actually encourage our board members when they and it's not an unusual happening to have an adjournment, to take a break, to ask questions of policy to get back. There might be a question of law that they want to consider. They can reach out to their own staff in their regions on time to time. They'll reach out to our legal staff at national office to get a clarification, so that it's not actually unusual at all. And we encourage them before they make a decision to, if they need to adjourn to sort of, get a second opinion on a policy or law, to do that.
Just another question on that. Why did neither of the board members or the acting vice chair realize that Galeese had repeatedly violated the Criminal Code of Canada by purchasing sexual services? They could have at least suspended day parole, correct?
Yes, they have a number of options in terms of their decision making.
And maybe just a little bit of a different question. On what date did CSC inform the parole board for the first time of the existence of the strategy where allowing Galeese to have sexual intercourse with women?
I do not have an exact date, other than I'm quite certain that it was presented as part of the release plan at his hearing on September 19th.
Okay, and I noticed in one of the reports that was given to us, I think from the commissioner, that you're having an independent review. I'm just curious, who are the two external community board members? Who do they work for?
They don't work for the parole board. As far as I know, they don't work for the Correctional Service of Canada. They're both, they both have been professors. I have their CVs.
So who do they work for?
Do you have their CVs there? I believe that they're both professors of criminology at two different schools somewhere in Quebec.
Okay, yep, thank you.
Okay, thank you, Mr. Morrison. Mr. Second.
Thank you, Mr. Chair. When I was reading the Corrections Service of Canada report, the recidivism rate in Germany specifically mentions sexual assault, whereas we often refer to violent crimes. I just want to clarify, when we say violent crimes, does that also include sexual assault?
Yes, it would.
Okay, thank you. Document that broke down the CSC's recidivism rates for the last 30 years, and I want to compare 2008 to 2018. In 2008, the number of offenders on conditional release successfully reaching warrant expiry date had a readmission rate of 48%. That's less than half. However, in 2017 to 2018, that number had increased to 61%, which is quite tragic. Can you speak to the work undertaken by CSC in recent years to reduce that rate?
To reduce the
increase in recidivism. Sorry, the decrease. So what work has been done to decrease it?
Oh, okay. To decrease. Okay, I was. I think it's a little bit what I said earlier. In 2010, we introduced what we call it the Integrated Correctional Program model, and it was implemented across the country. We completed the implementation in 2017, and we've seen actually really good results in terms of, and I have them here with me. So definitely programs help in reducing the risk that the offender presents. In terms of, if I look at Indigenous offenders, we've created Indigenous intervention centers in our institutions where they get access to programs earlier. We work with them. We have pathways. So there's a number of things that have been done to also increase the success rates of Indigenous offenders. For women offenders, we have what we call the Circle of Care program. It's a continuum of care program. So there's a number of things over the years that have been done to reduce the risk of reoffending. We've also developed some actuarial tools. So, for example, the Criminal Risk Index that determines an offender's level of risk and also the intensity of the program that the offender should participate in is a fairly new tool that was developed that also helps parole officers.
Thank you. Mr. Chair, I'm going to give the remainder of my time to PS Joel.
Mr. Lightbound, you have a little less than 2 minutes.
Merci beaucoup, Monsieur le Président. Merci à vous tous pour
Thank you very much, Mr. Chair, and thank you all for being here. I will echo the sentiments that have been expressed. I extend my condolences to the family. I think that's absolutely necessary. And as my colleague from the Bloc Québécois, I think it's important to see what actually happened in memory of Ms. Lévesque. And there are things that have to be assessed. We have to be sure that all of the processes were followed and that where there were mistakes, there will be no more mistakes of that type. Ms. Kelly, you ordered a review of community services offered throughout the country. And I was shocked to see that in Quebec, agents could include, or officers could include in their release plans, solicitation of sexual services. So I was wondering where you are in that review, and I'm wondering whether that happened elsewhere than in Quebec or whether it's been stopped completely. First of all, the review is underway. We have a number of community strategies that must be reviewed, but I was very clear as soon as I heard about this tragedy. I communicated immediately with the regional deputy commissioners and asked that there be a review of all community strategies. I also asked parole officers and supervisors be met with individually to discuss case management practices that have to be robust, and also to talk about the importance of quality control of documents. There are certain things that we did immediately as soon as I found out what had happened. Thank you, Mr. Lightbound. Mr. Gould. Thank you. My questions are for Ms. Ode. The two board members had the power to act when they found out that Galese, who had been sentenced to life imprisonment, had been violating the criminal code with regard to relations with women. But why weren't the board, why didn't they just suspend day parole immediately?
I believe that they and the Board of Investigation will probably look into that. But, it is, in the end of it, it is an independent decision. They took all the information that they had before them, and the decision was made. I'm not here to justify it. I'm not here to condemn it. Each board member's decision is a decision in and of itself, and I believe that with all the training that they have, all of the information that they took, they thought that that offender could be managed successfully in the community with the various conditions that they put onto his release.
Merci. Vous êtes satisfait?
Thank you. So you are satisfied that even though they had the power to do it, they did not ask for a new risk assessment. It was their decision, and you're satisfied with their decision. Is that what you're saying?
I'm going to wait for the Board of Investigation to report back to us and see, if there were things that could have been done, that should have been done, and how we can, improve in the future.
Merci. Ariane Garneau, c'est une amie de...
Thank you. Ariane Garneau is a friend of Marie-Laine's, and she made a statement on the GE program on TVA, and I'm quoting, "I am angry at Galese in particular, but I'm even more angry with the people who decided to release him." Do you realize that the victims of criminal acts will no longer have trust in the organization that you lead?
I'm going to say that he was released in September, in March of, he had been released in March earlier. This was a second, and by law, we must review those released on day parole every 6 months. So he had been released actually in March. This was a second release, and I would say to anyone who's disappointed, I think we're all disappointed. We're all shocked. We're all quite. I would say devastated by what has happened, but I also think that, and I know it doesn't sound quite right, but that our success rate is that 99.9% of those on day parole do not reoffend violently. So we do the best we can in terms of making our decisions. We use the best tools available that we have. We take all of the available information, and perhaps, in some cases, all of the information isn't there.
Merci. Donc, vous êtes consciente que cette triste.
Thank you. So you are aware that this terrible event has destroyed the credibility of your institutions and Canadians' confidence in conditional release. You're aware of this?
I am not aware that, in fact, it has destroyed all of Canadians' confidence, but I'm certainly aware of the potential. I'd say to this committee, too, that the Parole Board, as one of the least understood, and I would say grossly misunderstood organizations in the
Madame,
criminal
je
justice
m'excuse,
system.
j'en ai seulement 45 secondes.
Sorry, I only have 45 seconds left. So the 20 September 2019 report of the Parole Board indicates that given the absence of concerns with regard to public safety, is it normal for board members who are informed about meetings with women did not express any concern with regard to safety, the people's safety?
Did express a huge concern. They said that this was unacceptable and was not to happen.
Je parle de avant de la décision.
I'm talking before the decision. Would an experienced board member written that?
Sorry, I don't think they knew before the actual hearing, but the Board of Investigation might.
Merci.
Okay.
Show that something else.
Monsieur Lightbound, 5 minutes, s'il vous plaît.
Oui. Alors, pour
Yes. I would like to follow up by asking about the joint investigation and perhaps explain to the committee what that is. And I would also say that in 2014, Christopher Falconer was found guilty of murder after having already murdered someone, and he was on day parole. And in 2014, under the former government, that same type of Board of Investigation had been created. Isn't that true? And were you satisfied with the recommendations made by and what was found about the case in question? Yes, that's right. There was a Board of Investigation that was set up, recommendations were made, and a follow-up was also done. In this case, it is a joint investigation by the Parole Board and Correctional Services Canada. The 5 members of the Board of Investigation will gather all of the information. They will talk to the people they need to talk to. And based on the information they gather, they will make recommendations. Those are recommendations that Correctional Services will take very seriously, because for us, public safety is the absolute priority. We want to know what happened in this case, and we do not want such a case to happen again. So we can expect that each decision at each step that led to the tragedy will be evaluated and that there will be recommendations about that. Absolutely. Perfect. So this was mentioned by my Conservative colleagues, but I'd like to ask about the experience of the board members. I'm not going to be, I don't want to be partisan, but Mr. Paulus led us there. But it's clear that we heard it. Mr. Blackburn, who was a Conservative representative in Pontiac, and 6 of the 9 board members who were there in 2015 had either given major funds or were candidates for the Conservative Party. We should remember that. But when we look at the experience of the 2 board members who made the decision here,
I maybe should have interrupted Mr. Paulus earlier when we strayed into partisan matters. I'm not quite sure what the relevance is as to who's making appointments, which government is making appointments. We're dealing with that.
J'accepte
So,
yes, I expect your ruling, but is that one of the most vocal criticisms came not only from a member Paulus, but also from Mr. Blackburn. And so with regard to the experience of the board members in question here, I would like you to tell us about that and perhaps get a bit more information about that. Were they experienced enough to make the decision that they made, Ms. Odes? So the board members who made the decision were experienced. They were full-time members, a part-time board member, parole board member, and a full-time one. There's a difference between the two because a part-time one will work 5 to 10 days a month, and then a full-time board member will work every day. So in this case, when it comes to the years of experience, they may have had fewer years of experience, but in terms of the decisions made, they had more experience making decisions, or at least as much as the part-time ones. With regard to individual names, I can't give you that information because I don't have it. But the board members who made the decision, yes, had experience. So, and we're talking about a former provincial commissioner and a parole officer. So I was wondering, so all of the board members at the Parole Board of Canada are supervised by the regional vice president, Mr. Bouchard, in this case. Is that right? And what is the form of that supervision from day to day?
Had taken some personal leave, so we have had another board member take on the administrative duties of the vice chair position in the Quebec region. Basically, vice chairs are, and it by law, responsible for ensuring that board members in their region are properly trained, ensuring that they are abiding by, the the board members' code of conduct. They're in charge of mentoring and coaching them to ensure that they are doing all of the votes that they need to do, and they're in charge of doing. We do have an evaluation, a yearly evaluation of all board members, and they would perhaps observe some of their hearings, or at least listen to some of their hearings, and that those evaluations come to both the executive vice chair and myself for review.
Thank you, Mr. Lightbound. Madame Michaud, 2.5 minutes, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Seeing as we can't get specific details on the case before us, I would like to know, to the best of your knowledge, have there been similar cases in the past where an offender had solicited sexual services, or is this really an isolated case that's never been seen before? And to the best of my knowledge, it's an isolated case. I have been with Correctional Services Canada for 37 years, and I have never seen it before. But that's also why I asked for a complete review of community strategies to ensure that it does not happen again. I was very, very clear with the deputy commissioners for the regions that this is not a practice that Correctional Services approves. So you're saying that you've never seen a case like this in 37 years? So you had seen some before? No, I've never seen any. Yes, I want that to be clear. In your opening remarks, you said that you could talk about the results of the investigation. How long does an investigation like that take usually? It takes quite a while for that kind of investigation because all of the information has to be collected, interviews have to take place, but we committed to a 2-month period about. There's also a criminal investigation underway. So even if the criminal investigation hasn't ended yet, will we be able to get the results of your investigation? The internal investigation? Well, the reason why I met with the chief of police of the city of Montreal was to make sure that the lines of communication remain open.
Et puis peut-être que M. Tousignan peut en dire plus long là-dessus.
Perhaps Mr. Tousignan can add to this because he knows about this as well. So I'd like to add that it's important for everyone to know that our investigation will have nothing to do with the criminal investigation, but we're working with the police to make sure that there is no overlap. So there might be some delays on our side if the Quebec police doesn't give us the green line to continue our investigation and interview certain people. Yes, thank you, Ms. Michaud.
For all of us, where is the police investigation? Because it's not clear to me, at least, where the police investigation is, because that does affect the questions that members can answer.
I spoke to the Quebec City Police as of yesterday, and their investigation is still ongoing. They still have witnesses and suspects to meet in the next few days. So therefore, their investigation is still alive and ongoing.
Okay, thank you. Final 2.5 minutes, Mr. Harris.
Thank you. And first of all, I didn't do it when my first intervention, but let me express my great sympathy for the tragedy that's occurred to Marie-Hélène Levesque, and her family deserve our sincere condolences and sympathy. This is a terrible tragedy that ought never to happen again. I want to go back to the situation that there's been some confusion here about statutory release, this and that, the other thing. And I want to quote from for the record, from the Parole Board of Canada information on the website of the Government of Canada. And in talking about life sentences, it says a life sentence means life. Lifers will never again enjoy total freedom. Not all lifers will be granted parole. Some may never be released on parole because they continue to represent too great a risk to reoffend. Lifers are not entitled to statutory release. So the conditions of no parole for 15 years in the case of the life sentence that Mr. Gillese had meant that he was not entitled to parole unless he could establish that he would not be a risk. So that's a very different than statutory release. You have to get out after serving 2/3 of your sentence. As you pointed out, 40% of the cases or 60% of the cases are like that. So this is a special a case of a person who's sentenced to life in prison for the murder of his wife or partner being granted parole. So therefore, a high degree of care has to be taken before a positive decision is made to release this person into the community who's still serving a life sentence. Am I right about that? And I say this to the parole board chair there.
Yes, I'd just like to clarify that for lifers, they will never be released unless through a parole board decision, because the statutory release doesn't apply to lifers. However, the court or the judge sets the time at which,
yes, we understand that.
Okay.
The number of years before which parole is not available.
And in actual fact, for lifers who have been released into the community, they actually serve on average 7 years past that eligibility date before they are released.
But that wasn't the case for Mr. Gillese.
Yes, he was released, and I don't have it with me, but I believe he had was it 10 years the judge set for his, and he was released 3 years after that.
He was sentenced 15 years with no parole. I think was the sentence. No, that's what's in the report.
Anyways, we can look into that, but he was released 3 years after his eligibility
date. That's your understanding.
That's my understanding.
With Mr. Harris, unfortunately, that's makes you out of time. Now, colleagues, we've been at this for an hour and 15 minutes. We could take a break. We still have 45 minutes to go. or we can continue on. I'm in the hands of colleagues as to whether we continue. Also, whether there's any urgency for any health breaks on the part of the witnesses. Well, we can go more. We can go 45 minutes. Do you want a 5-minute break?
5-minute break.
5-minute break? Okay. With that, we'll suspend it for 5 minutes. Colleagues, could we come back to the table, please? Colleagues. Okay, we are resumed. Mr. Harris, you got a point of order.
Yes, Mr. Chair. I believe that the chair of the parole board would like to correct the Mr. Galise's sentence and timing of the of his release for day parole and the length of his time that he was required before he was eligible for parole.
Okay, do you want to?
Yes,
Correct
yes, I
record
would.
then?
I just
Okay.
just for the record, so it was a life sentence with no parole eligibility, no full parole eligibility for 15 years. Day parole, actually, they're allowed to apply 3 years before their full parole eligibility date. So he became eligible for day parole in 2016. When day parole was granted, it was 2019.
Okay, thank you for that clarification. Thank you, Mr. Harris. And that really was truly a point of order. Shocking development. Okay. With that, Mr. Shipley, 5 minutes, please.
Thank you, Mr. McKay. My question is going to be for Ms. Kelly. We're here today because of a tragic death of a young 22-year-old woman. And we're here to get to the bottom of how this happened and try to make sure this never happens again, obviously. I'm going to quote right from Ms. Ode's opening remarks, so I'm not mistaken at all, that this tragic death is partly because of during this hearing, the parole officer presented to the parole board members a release plan that included an element that would allow this offender to solicit women for sexual purposes. Something we had not heard anything of, and I need to know, and I'm sure the family needs to know, what has happened to the parole officer, and are they still employed?
So the parole officers directly involved in this case are currently not supervising offenders.
Have they been disciplined, so they are still employed?
We're waiting for the Board of Investigations to complete their work. Once they've completed and we have all the facts, if we need to undertake another investigation, we will do so.
Okay, thank you. Mr. McKay, I'd like to give the rest of my time to Mr. Pohus.
You have a little less than 3 minutes.
Ouais, merci, Monsieur le Président. Donc,
Thank you, Mr. Chair. So the agent, Ms. Grégoire, who created the report and the strategy, who is the supervisor who authorized that strategy. I don't have the name, but the supervisor for Sophie Grégoire would have been someone from Correctional Services of Canada. Can we have that person's name? You don't know it, but you can give it to us? Yes? Okay, good. In 2018, the Auditor General audited Correctional Services and found a number of gaps with regard to risk assessment, and there was a gap with people who worked in that area. What do you have to say about that? So there was a gap in expertise of people doing risk assessments. Well, parole officers always have to assess the risk for the offender. It's continuous. But what about the competence of those people? It was questioned by the Auditor General. Do you agree with that? This was in 2018. Ms. Kelly, if you don't have it in front of you, we don't really have time to look for it. So I'll ask another question. No, but what I can say is that naturally our parole officers receive training. It lasts 4.5 weeks. And every year they get 5 years of professional development training. And really, there is a lot of emphasis on risk assessment. So you were present when we looked at the investigator's report. So 6% of the budget of CSC goes to community services, and 40% of offenders are on day parole. So what can happen there? So it's not a question of money, it's a question of allocating the resources. So there's a problem with following up with offenders in the community, and there are more and more of them being released. Answer. So when I was here, I said 6.43%, and that's what is there for infrastructures in the community. So those are the community residential services and the health services as well, but it did not include the parole officers in the community who fall under case management in the budget. So when you take that into account, it's 11.3%. When it comes to parole officers and the resources for them, as I was explaining to Ms. Michaud, we have a formula for providing resources for those officers, and it takes into account the time that they're available for work. So we include sick leave, vacation, or statutory holidays, and then the time that it takes to write reports, the time it takes to carry out supervision activities, and also the time it takes them to get to where they must supervise the offender. That formula gives us the number of parole officers that we need in a community setting. Once a year, we look at that formula again, and this year we can see that if parole officers are taking more sick leave than we thought they were going to take, well, then we have to readjust the formula. So despite the fact that it's also based on the number of offenders in the community, what is the biggest impact, what has the biggest impact is the level of supervision of the offender. If it's 8 times a week, 8 times a month, 4 times a month, once a month.
And I, too, would like to start by extending sympathy to Ms. Levesque's family and acknowledge that this was a tragedy, but also one that it was extremely rare. I think everyone has acknowledged that, including the correctional investigator when he appeared here. And I also want to start by acknowledging the good work that parole officers do in the community. And Ms. Kelly, I know you would agree with me on that. They do yeoman's work to keep us all safe. And I want to talk a little bit about the cuts that were made under the Debt Reduction Action Plan under the previous government. I got a report that was done in 2015 by the Canadian Centre for Policy Alternatives, and it was called The Impact of the Harper Government's Tough on Crime Strategy. And in it concluded, according to frontline workers, the Harper government's tough on crime strategy and restrictive budgetary measures undermine public safety. So there were over $200 million of cuts that were made. And I saw the impact in Winnipeg with police liaison officers that had been cut in community, the reduction of frequency of contact between offenders and parole officers, lack of community programs, and even cutting a family violence program. So, Ms. Kelly, I'm not asking this question as an insult to the work that's done at corrections, but more I've heard from frontline officers. I've heard when I visited facilities that DRAP, as it was known, had a huge impact on being able to deliver programs. And I'm just wondering if you can talk about that, because we've tried to reinvest in corrections. I think it was $343 million in the last budget, but it's hard to catch up when we were coming from so far behind. So I'm just wondering if you could comment on that.
Well, obviously, yes, there's a significant amount during DRAP that was cut. We obviously looked at what we needed to do. The one thing at the time, certainly the commissioner at the time was clear that we shouldn't cut in frontline delivery services because those are of vital importance to keeping our communities safe. I understand, for example, that the CCLOs are no longer exist, but by the Community Corrections Liaison Officers. But by the same token, what we've done is we've introduced security intelligence officers in the community, which we didn't have before. So,
but with respect, I went to the Winnipeg CC, the Community Corrections Office, and it was a commissionaire that was there providing security. And he was just an old, retired, I'm sure he's a lovely man, but I would much rather have seen a police officer in that facility than have seen a commissionaire sitting there.
Although I don't believe with the CCLOs, it's the police officer that would have been sitting in lieu of the commissionaire. But it's clear that at CSC, I mean, we have to to manage within our budget. We have to prioritize. We have, and I see some of our union members are here today, but we have discussions with them, regular discussions.
I have a question for Ms. Oates as well. So in this report as well, it said that in 2015 there were no Indigenous parole board members. And I know that the appointment process changed under our government. So in Quebec, under the previous government, 8 out of 9 appointments were men. 6 out of 9 were Conservative Party members. I'm wondering if you can speak a little bit to the diversity that's on the board and also the merit-based appointment as opposed to the previous appointment process.
Well, I wasn't here I wasn't aware of how that previous process worked. But I can say that there has been a huge push, a huge emphasis to look at ensuring that we reflect more of the Canadian population than we have in the past. So 53%, as I said, are women. Now, 53% of our board members. 7% are visible minority. 12% are now Indigenous people. So there has been improvement over the years.
Are you confident that they are experienced and qualified and are making good decisions in these cases?
Yes.
Thank you.
That's the kind of brief answer we love. Mr. Paulus, I'm sure you'll be equally brief. 5 minutes, please.
Merci, Monsieur le Président. Donc, on parle.
Thank you, Mr. Chair. So Mr. Lightbound was talking about crass partisanship, and we just heard some more partisanship about the 2008 budget. And so the Liberals have been in power for 5 years, and these decisions were taken by board members that you appointed. So we have a real problem with the appointment process because there was a purge in 2017, and that went back to 2015. 33 vice chairs of commissions throughout the country received letters from the Liberal government asking them to resign. And there was the one in Quebec as well who received a letter asking him to leave. And so that's pressure on independent officials, because you're saying they're independent, but there's pressure. So the 2017 purge was one where the mandates of the board members in place were not renewed. And that was based on the fact that the Liberals wanted to ensure that no Conservatives were there anymore. And Dave Blackburn was a candidate after being a board member. And he wasn't in politics with us before that. So with regard to all of that, it's important to understand that what Ms. Damov said is that there's an ideology to ensure that there's change, that there's diversity, women, Indigenous board members, but you've taken away the expertise of people who can make decisions about criminals, killers like Galese, in order to inject diversity.
I take real offense to that.
J'ai jamais dit que les femmes n'étaient pas qualifiées. Ce que je dis, c'est qu'une.
I didn't say that women are not qualified. I'm saying that it was a political decision that was made by the Liberal government not to renew the mandate of experienced people because they had conservative connotations. And the board members will be able to tell us that themselves when they come and testify. But there's an ideological approach to bring in diversity. It's not a bad thing to bring in diversity, but what the bad thing is to have lost the expertise of the board members who were there, so that the 2 board members who made the decision did not have the experience needed to do the work properly. Because if they had had the proper expertise, they'd have sent Galese right back to prison. Do you agree with me, Ms. Oates?
And I want to say that we actually did a bit of a review of how board members have changed over the last 20 years. And I'm going to say to this committee, to each of you, that whenever there is a change of government, you see a big change in the makeup of the parole board. In terms of the experience, there is a regular churn. Part of it's by law, 3-year appointments. It takes close to 6 months to a year to get a board member completely ready to vote on all different types of votes. And there are very many different types of votes. So experience, someone who has 5 to 10 years of experience of a board member is really quite remarkable. This isn't a career. These are appointments for 3 to 5 years. So there is a constant churn. I have 21 appointments that will term off this year. So I'll be looking for either people who want to be renewed and some don't, or bringing in new board members.
Ça, on le comprend, mais l'expertise qui a été
I understand, but the experience and expertise that was lost in 2017 was catastrophic, and so that's why there were eight board members who sent a letter to Justin Trudeau saying that the main mandate is public safety, and that mandate was being endangered. That you were aware of the letter, Ms. Kelly? You haven't read it, but as the commissioner, do you believe that having lost that expertise is irrelevant, or is it something that's unacceptable?
I don't believe that there was a huge loss of expertise over the entire board. There have
Québec, la section Québec a perdu son expertise.
But the Quebec section lost its expertise, and the vice chair, Mr. Bouchard, was sent away.
Appointed by this government with their who have lots of expertise. I would also say that and I think my colleague here sort of suggested that it's not the year's experience, it's how many votes you do. And I'm going to tell you that one of the people who has been quite outspoken had less votes in 3 years than the 2 board members who made this decision. So that's experience.
Ils ont pris une mauvaise décision parce qu'ils n'ont pas pris d'action.
But they made the wrong decision. They didn't do the right thing.
We're talking about 2 different things here.
All right, thank you, Mr. Palouse. Madame Cara, 5 minutes, please.
Thank you, Chair. I too would like to first and foremost send my deepest condolences to Marilyn Levesque. And we know that we need to do a better job as a committee and as all members to make sure that nothing like this happens again. I want to talk a little bit about the parole board versus the parole officers. As has been mentioned, there has been a lot of misinformation, in media by some of members in the House. Madam Otis, can you talk a little bit about the specific difference between parole board members and parole officers, and how are they? Because I think people don't get it, quite honestly. And can you talk about? Can you clarify that parole officers are under the umbrella of Corrections Services Canada, not under Parole Board of Canada?
Yes, I can. I'll clarify it. I want to go back to actually a little bit of history to the McGuigan report, because back in the day, in the 70s, we were the National Parole Service, and we actually, all the parole officers in the community did report to the parole board. The McGuigan report said that really didn't look too great, and we should change that. So the Penitentiary Service became, in 1979, the Correctional Service Canada, and took over all of the parole officer responsibility. The Parole Board of Canada, as it became known at that time, became a decision-making body only. So to stop that, what could be seen as conflict of interest. Parole board members are GIC appointments, every single one of them. They have terms of 3 to 5 years, and parole officers report to the report through the Correctional Service of Canada, and are responsible for the day-to-day supervision of parolees in the community.
Thank you for that clarification, because I know. Even in this committee, when members are asking questions, I looked at some of them are asking questions to the wrong witnesses, actually. Can you also talk a little bit more about the training program that you talked about in your remarks for the parole board members? What does that actually look like, and is it ongoing? And Just your comments on that.
Absolutely, and I'm going to ask my colleague, because she is responsible for the board member secretariat, to respond to that.
Sure. So anybody appointed to the board, whether we come from, and I say we because I come from a correctional background, I am now a board member, so I had to go through the training process. Our board members all spend time in the region for a few weeks getting to understand what their job's going to be, observing hearings, meeting other board members, meeting staff. They come to the national office where we bring in experts on women offenders, lifers, sex offenders, violent offenders, our risk assessment framework. They learn about risk assessment. They return to the community office across the country, and they continue their training there. So once that training is complete, that initial 6 weeks, 5 to 6 weeks, the vice chair will decide whether or not they should start voting on specific cases. So they may be able to do day parole cases, but not more difficult cases. So it's a gradual beginning. They do it, they're paired with either the vice chair or another board member of experience. Other than that, we have ongoing training. So we have an intensive Indigenous training with elders. We usually do it either in Montreal for our Francophone offenders or out west for our other board members, not offenders, board members. That was a slip, sorry. So for 3 days together with Indigenous communities, learning about, displacement, the community impacts, Gladue, twins, really those decisions that have had a significant impact that they will have to make decisions on. And then there's ongoing regional training, and Martin, as the regional director general in his office, is responsible for that with the vice chair. So sometimes it's staff from Corrections Canada that comes to talk to us about programs. It's us visiting halfway houses. It's us meeting with the John Howard Society. And then yearly, we have our annual training, which is a week-long intensive for board members on risk assessment. So it's continuous. If at any point a vice chair says, I have a board member that has some concerns with a different type of offender, or there's a concern about decision making, we come together with a team and bring them in. So it's not like everybody doesn't get the same thing. There's the base, and then there's I have 28 years experience. I probably got a little bit less than somebody coming from a different background, but we all get the same first 6 weeks, and then we build from
Thank you, Madame Cara. Madame Michaud, 5 minutes. Oh no, 2.5 minutes.
You have 2.5 minutes. Ms. Michaud, I'd like to come back to the investigation, because earlier you were saying that it was 2 months and 2 independent investigations, one with the Quebec Police Service, and we won't be able to get the conclusions of your investigation until the police investigation is completed, or will we have them in the next 2 months? Answers. Not necessarily, but we have to work very closely with the Chief of Police of Quebec City to make sure that we are not creating difficulties for either of the investigations. So we committed, though, to commit our investigation in the next 2 months. So there's an answer that seems very clear right now, and that's why we supported the Conservatives' motion to have a public hearing to see what actually happened. But because we can't speak specifically about the case, we have to wait for the results of your investigation. But I have the feeling that the system won't question itself and condemn itself. But where do you think the problem in the system is? Because the system failed us somewhere. So the parole board categorically rejected the strategy of allowing the offender to seek sexual services. So it seems like it's the parole officer who's being blamed. But what do you think personally? Well, we have to wait for the end of the investigation. But what I can say is that we do not support having offenders solicit sexual services. That's clear. I made that clear throughout the organization. And what we'll do is that we do not want this kind of tragedy to occur again. So when we get the recommendations of the Board of Investigation, we will look at them closely to make sure that we implement measures, if necessary, to prevent such a tragedy That's it, unfortunately.
Thank you. Madam Commissioner, the Auditor General found in 2018 that parole officers at CSC didn't always meet with offenders as often as needed to manage their risks to society. And they found that they didn't always monitor offenders' compliance with special conditions imposed by the Parole Board of Canada. Now, of course, we know in this case the parole officers weren't doing face-to-face supervision at all. But I do also note that in the survey done by the union, which is reported by the Library of Parliament to us, 2/3 of community parole officer respondents agreed or strongly agreed with the statement, "I worry that I'm not able to adequately protect the public given my current workload." In light of these two statements from different sources, do you think that it's time that there was a reallocation of some resources within the Correction Services of Canada towards more support for community supervision as recommended by the correctional investigator?
Well, first of all, just on the monitoring special conditions, we did take to heart the recommendations from the OAG and did put in place some measures. We actually amended the policy to ensure that on a monthly basis, district directors ensure that special conditions are monitored, as well that the frequency of contact is met. Again, we have, as I explained, a resource formula for community parole officers.
These two statements then bear no relation to the reality that, as you see it, that there's inadequate opportunity to supervise and that the parole officers are concerned about the inability to have time to supervise to monitor the risks. There's no relation to those.
Not necessarily, but in terms of
let me continue then. Given the fact that, as just pointed out, when you have a life sentence, particularly for a violent crime, you're still always under the supervision of the CSC. How do you account for the fact that you don't have an adequate resource to ensure that the monitoring of the risk is still always present? When it's pointed out that the percentage that you're spending on community release, where 40% of offenders are, as opposed to incarceration, is so disjointed and according to the correctional investigator.
Thank you, Mr. Harris. Regrettably, again, Mr. Harris has asked a question.
I think it's on the record, sir.
Yeah, you certainly have established a pattern, Mr. Harris, for asking questions and then not allowing time for answers. With that, Mr. Morrison, 5 minutes.
Thank you. I've reviewed your annual performance report since 2015, and I noticed that in there's just no reference to performance agreements, employee performance reviews, and recommendations. So I'm not sure how your hierarchy is for the supervision of your staff. Who is actually, in this case here, who is the supervisor for the parole officers that are involved? Is there a supervisor who monitors your employees, and is there performance reviews, not on the results of people who are released, but on the staff themselves, so you can monitor if they need more training, for example?
Absolutely, yes. So parole officers are supervised by parole supervisors. I was a parole supervisor. Every employee has a performance agreement with certain objectives that must be met. Every year there has, actually more than once a year, there has to be a meeting with the parole supervisor where the performance is discussed. If there's a need for extra training in a certain area or need for taking certain courses, that's discussed with the employee.
Okay, so I know then through the Board of Investigation that this will all come out. If has been some performance reviews done on the individuals whether it's even the supervisor, and who does the supervisor report to, so that there is kind of a chain of command kind of.
There is. So in the community, there's a community parole officer, there's a parole supervisor, then there's an area director and a district director.
And they follow up on corrective action if required.
That's right.
Okay, Mark.
Oui. Question pour Monsieur Van.
Yes, I have a question for Mr. Van Ginhoven. According to former board members, the lack of board members has increased the work and has caused a burnout of clerks. The Montreal office had to hire a mediator to resolve the conflicts between the clerks and you. How many clerks left after you arrived in your position at the Montreal office? How many burnouts have there been? Do you have those figures? I do not have the figures for burnout. If I recall, I think that 2 clerks retired have retired since 2014, since I took my position. Thank you. We would like the report of the mediator in this case be tabled to the committee, please. I also now have a question for Ms. Odes. Would you admit that the permanent strategy to meet women for sexual purposes was a major and concerning risk?
Oui. Donc, si cette stratégie constituait un facteur de risque.
So if that strategy was a major and a concerning risk, why not end Galese's day parole?
Decisions are independent. They would have weighed that against everything else that they are seeing in terms of past performance, in terms of the risk that they thinks he would pose to the community, and the measures that are put in place to manage that risk. And at the end of it, people come up with either a yay or a nay. In this case, they came up with a decision to continue day parole.
Oui, une autre question, c'est quelques-uns.
Another question. When Galese's family met him at Christmas 2019, they saw that he was completely out of sorts. How is it possible that the parole officer did not notice or state that he was confused and disorganized? Is there not an obligation on the part of officers to report that kind of thing? So that is up to the parole officer. So I can't talk about the specifics of this case, but when offenders are being supervised in the community, there has to be a relationship with the people who are in that offender's life to be able to check certain types of information. So if there was information about a person being in a disorganized state, well, then the parole officer would have had to take measures.
Clarification, you referenced a report?
Oui.
And can you be specific for the purposes of the
Oui,
analyst?
je peux vous donner le nom après.
Yes, I can.
Yakanoko.
Merci, Monsieur le Président. Madame.
Thank you, Mr. Chair. Ms. Odes. Is the offender population more and more complex today? And if so, do parole board members receive more adapted training regarding these complex cases?
And I would like to actually just pick up on the complex cases. Over the years, with the, I'm going to say the continuing growth of the lifer population, people serving indeterminate sentences, when board members now review those files, they are massive. I would like, quite frankly, if I can say to this committee, it would be nice for board members to have more time to study. I'm going to tell you a board members' day. Monday, they study for 3 to 4 hearings, which happen on Tuesday. Then on Wednesday, they study again for 3 to 4 hearings that they'll hear on Thursday. And then Friday is generally a time when they have 6 paper votes, as we call them, paper votes. So it is a full workload. And with the complexity and just the sheer volumes of files for a growing number of lifers, yes, it would be nice for board members to have more time to study.
Merci. Tout à l'heure, vous avez parlé.
Thank you. Earlier, you talked about the number of years of experience, the number of years worked, and the number of votes. Could you clarify that for us? Because you said it's not the number of years that matters, it's more the number of votes that matters when it comes to experience. Could you clarify that for us?
The expectation is that you will work 5 to 10 days per month for the board making decisions. So they're going to have less decisions, less hearings over that 3 years than someone who is full-time and is doing it every single, is basically doing voting full-time.
Vas-y.
Merci Angelo, merci Monsieur le Président. Petite question, quels sont les...
Angelo, thank you, Mr. Chair. What are the legal criteria that guide board members when they must decide whether to grant day parole to an offender or not?
That protection of the public is the paramount consideration. The second is that the offender will not, by reoffending, present an undue risk to society before the expiration of the sentence. And it's not an or, it's and, the release of the offender will contribute to the protection of society by facilitating the reintegration of the offender into society as a law-abiding citizen.
Je comprends qu'on peut pas, vous pouvez pas commenter sur la façon dont ces critères-là ont pu être pondus.
Yes, I understand, and you can't comment on how those criteria were taken into account by the board members, and that's why we are awaiting the joint investigation that will take place about this particular case to see whether those criteria were taken into account. But have the criteria changed over the last few years? Inaudible to the interpreter.
Criteria have remained in place since the CCRA came into law. Other than the protection of society, is a paramount consideration. Was always there since 1991. Two. It was, however, moved up a little bit in the principles just to make it more clear. But other than that, it has not changed.
Merci.
With that ends our questioning, and I want to, on behalf of the committee, thank the witnesses and for their testimony, and reiterate on behalf of the committee our deepest sympathies to the family and the incident that unfortunately brings us here. So with that, we are adjourned.